time of the elite murder, was second in command of the Indian naval ship Mysore. He married Sylvia in 1949 in the registry office at Portsmouth, England. They have 3 children by the marriage. A boy aged 9 years and girl aged 5 years, and another boy aged 3 years. Since the time of the marriage, the couple was living at different places having regard to the existence of service of Nanavati. Finally, they shifted to Bombay. In the same city, the deceased Ahuja was doing business in automobiles and was residing along with his sister in a building called Shreyas till 1957, and thereafter in another building called Jeevan Jyoti is Stivated Road. In the year 1956, Agnik, who were common friend of Nanavati and Ahuja's, introduced Ahuja's and his sister to Nanavati. Ahuja was unmarried and was about 34 years of age. At the time of the death, Nanavati, as a naval officer, was frequently going away from Bombay in the ship. Leaving his wife and children in Bombay, gradually friendship developed between Ahuja and Sylvia, which culminated in legitimacy between them. On April 27, 1959, Sylvia confessed to Nanavati of her illicit intimacy with Ahuja enlarged at the conduct of Ahuja. Nanavati went to his shop, took from the stores of the ships a semi-automatic revolver and 6 cartridges on a false pretext, loaded the same gun to the flat of Ahuja, entered his bedroom and shot him dead. Thereafter, the accused surrendered himself to the police. He put under arrest and in due course he has committed to the session for passing a charge under 302 of the IPC.
With regard to this issue, only the Honorable Court, the accused is guilty of murder, should be punishable under Section 302 of IPC. Section 300 of IPC, murder excepted in the case hereafter exempted. Culpable homicide is murder if the act by which the death is causing is done by the intention of causing death, or the secondly, it is done with the intention of causing bodily injury as the offender knows is likely to cause death, the person whom to harm is caused on. Thirdly, it is done by the intention or causing bodily injury to any person and any bodily injury intention to the inflict insufficient to the ordinary course of nature to causing death. Or fourth, if the person committed the act known that the no immediately danger that is must be probability causing death on such bodily injury as likely to cause death and committed such act without any excuse for incurring the risk of causing death or such injury or foresight. In this case, on April 27, 1959, Sylvia is confessed to Nanavati of her intimacy with Ahuja. Enraged at the conduct of Ahuja, Nanavati went to his ships, took the stores of his ships or a semi-automatic revolver and 6 bullets on a false pretext, loaded the same, went to the flat of Ahuja, entered by bedroom and shoot his death. It is simply a murder.
Good morning, sir. I would like to present the accused case with my colleague Maru, and may I proceed the case? A plain reading of exception 4 of the section 300 of IPC shows that the following 4 ingredients are required. The first one is there must be a sudden fight. In this case, there was sudden fight between the Ahuja and Nanavati. Second, there was no premeditation. The fight was unexpected and there was no intention of either of the parties to kill or cause the death of any person. Third, the act was committed in a heat of passion. Fourth, the offender had not taken any undue advantage or acted in a cruel or unusual manner.
Good morning, sir. Exception 1 to Section 300 IPC provides that culpable homicide is not murder if the offender, whilst deprived of power of self-control by grave and sudden provocation, causes the death of person who gave the provocation or causes the death of any other person by mistake or accident. The provision to Exception 1 to Section 300 need not be considered in this case. The exception applies only if the death is caused during the time offender is deprived of power of self-control as a result of grave and sudden provocation. The degree of loss of power of self-control in this himself is that of a reasonable person having regard of degree of gravity of provocation.
In the present case also, when the accused went to Ahuja's house to confront him and ask him if he would marry his wife, then Ahuja replied in a negative and said, "Am I to marry every woman I sleep with?" Hearing such remark about someone's wife, a person with ordinary prudence would definitely get enraged, and at the same time, same thing happened with the accused. Then he lost his self-control, and as a result of scuffle entered between both of them. In case Empress versus Kogai, the court held that the use of abusive language constitutes a sufficient provocation to deprive a person of self-control. The judgment significantly highlight the cause and the effect of verbal provocation and how the abusive language can provoke a person enough to lead them to commit an impulsive or violent act.
Respected sir, in Birsa Singh versus State of Punjab, it was held that in the absence of any circumstances to show that the injury was caused accidentally or unintentionally, the presumption would be that the accused had intended to cause the inflicted injury, and the conviction was upheld. The Supreme Court further laid down in order to bring a case within clause 3 of section 300. The prosecution must prove the following. First, it must establish quite objectively that a bodily injury is present. Secondly, the nature of the injury must be proved. It is purely objective investigation. Thirdly, it must be proved that there was an intention to inflict that particular bodily injury, that is to say, that it was not accidentally or unintentionally, or that some other kind of injury was intended. Once these three elements are proved to be present, the inquiry proceeds further, and fourthly, it must be proved that the injury of the type just described, made up of the three elements set out above, is sufficient to cause death in the ordinary course of nature. This part of the inquiry is purely objective and has nothing to do with the intention of the offender.
A person is not held legally accountable for their actions. Section 97 specifies that the right of private defense under this section defends when a person can kill someone in self-defense. But Section 99 clearly mentions that the right to private defense can only be available when there is a reasonable apprehension of death or grievous hurt to the person, and in case there was highly possibility of death of Nanavati. Regarding in this case, Srinagar Kumar versus Union Territory of Chandigarh. In this case, the knife blows were inflicted in the heat of movement, one of which caused death of the deceased. The court held that the accused is entitled to benefit of exception 4. The occurrence was in sudden quarrel and there was no premeditation.
Exception 1 of Section 300 murder does not say that act must follow immediately after provocation, but the act must not be done after such interval of time as is sufficient in common course of feelings of reflections. But in the case in hand, accused got angry, but he still somehow managed his anger and went to Prem Ahuja with request that he marry his wife Sylvia. But after hearing remarks made by Prem Ahuja, he lost his temper, and thus the requisite exception necessary for this case to fall under exception 1 of Section 300 are fulfilled, which are as follows.
The deceased must give provocation. In this case, remarks of Ahuja about wife of the accused were derogatory and provocative. The provocation should be brave and sudden. No man of ordinary prudence can ever hear a derogatory remarks about his wife, and it was grave and sudden provocation. The offender, by reason of said provocation, should have been deprived of power of self-control. The accused killed the deceased during the continuation of deprivation of powers.
There is no sudden and grave provocation by his wife at noon on April 27, 1959, where there was sitting at the sitting room from the lunch to be served. The accused put the arm round his wife. effectively when he seems to go tense and respectively. After lunch, when he cautioning his wife, cautioning about the fidelity, she shook head on the indicate that was unfaithful to him. He guessed that as a paramount was Ahuja. However, thereafter he drove his wife to his children with her neighboring children in a car to a cinema. Dropping their promise to come pick at 6 p.m. when she show ended. He then drive his car to his sick as he want to get medicine for his sick dog. He represented to the authority to the ship that he went to draw a revolver and 6 rounds from the store in the ship at one going to the drive along to Ahmednagar by night. So he really proposed with a shoot himself on a receiving the revolver and 6 bullets and put inside our brown envelope. Then he drive his car Ahuja office and not finding him there. He drove the Ahuja flat, ring the bell, and when he opening by the servant, walked to the Ahuja bedroom, went into the bedroom and shut the door behind him. He also carried with his envelope containing the revolver, entering his bedroom and shooted it dead. It is this clearly states that there was proper planning by accused. There is not a case of grave and sudden provocation by his wife.
Nanavati got an argument with Ahuja because Nanavati knew that Ahuja does not care his wife and the children. They got into a scuffle and usually Ahuja made a sudden grab at the envelope. Nanavati drew his revolver and asked Ahuja to back off. As a result, a scuffle arose between them. 2 bullet shoots were mistakenly fired, which led to the death of person Ahuja, and it was all made in private defense.
Nanavati has already confessed to police that he drew all the gun because he wanted to commit suicide. He put the gun in round envelope, which clearly showed that he did not have any intention to kill Ahuja. He went there only to confess Ahuja about his affair with his wife. But the derogatory remarks the Ahuja gave to Nanavati led to grave and sudden provocation, and the scuffle between the two accidentally killed Ahuja.
No, suppose because I have very first disagreement was on the point that the Prem Ahuja has just gotten out of the shower and his towel was still in it. It was still on his body when it was discovered. It has not fallen, which is quite surprising because Nanavati and Prem Ahuja has a scuffle between them.
Nanavati was emotionally weak at that moment and thought nothing beyond securing the future of his wife and children. The prosecution must establish beyond a reasonable doubt that accused committed unlawful killing and that accused had the requested medicine.
Nanavati was in all his senses calm and composed. After Saliva confessed the Nanavati, he calmly drives to the movie theater and dropped them there. After this, he went to his seat and bought the revolver on the false pretendment. As per the statement of Deputy Commissioner of Police Nanavati, admitted that he shouted Ahuja and even correct his name was misspelled in a police record, which demonstrated that he was capable of thinking normally of this movement.
In OCS put the burden of proof on prosecution, section 80 of IPC, which is general exception, it states that an act not to be considered an offence if it is done accidentally or due to misfortune. Given that there was no criminal intention or awareness of the sum, the act must be done while engaging in lawful activity. By lawful means while exercising proper care and attention. If someone unintentionally commits an act lawfully without any criminal intention, then that person shall not be punishable under this section.
Pre-planned and premeditated murder because this is clearly show that he had sufficient time to cool down and the provocation was neither group nor sudden. Nanavati has premeditated the murder on his way. Nanavati, after shooting Prem Ahuja, left the place without informing his sister, who was present in the room next to him. If it was an accident, Nanavati must have informed her.
Nanavati, after the whole event took place, drove to the police name is Hoya Moli Kapu, consists in 1881. The murderers are held to apprehend that the plea of grave and sudden provocation, where the accused saw his wife cohabiting with a bitter enemy of him, and after some time his wife was seen again with the same enemy. The court held that the accused had served sufficient provocation to bring the case within the exception.
Sir, in case Mahmood versus State, the provocation was sudden, the provocation was grave, and loss of self-control. These three ingredients may be considered one by one. Whether the provocation was sudden or not does not present much difficulty. The word sudden involves two elements. Firstly, the provocation must be unexpected. If an accused planned in advance to receive a provocation in order to justify the subsequent homicide, the provocation can't be said to be sudden. Secondly, interval between the provocation and the homicide should be brief. If the man giving the provocation is killed with the minute after pre-provocation, it is case of sudden provocation. If the man is killed 6 hours after the provocation, it is not a case of sudden provocation. The main difficulty lies in deciding whether a certain provocation was grave or not. A bare statement by the accused that he regarded the provocation as grave will not be accepted by the court. The court has to apply an objective test for deciding whether the provocation was grave or not. A good test for deciding whether a certain provocation was grave or not is this. Is a relative man likely to lose self-control as a result of such a provocation? If the answer is the affirmative, the provocation will be classed as grave. If the answer is in the negative, the provocation is not grave. In this constant, the expression reasonable man means a normal or an average person. A reasonable man is not the ideal man of the perfect being. A reasonable man may lose self-control as a result of grave provocation. A reasonable society, a judge should not impose personal stand in this matter by training a judge of behavior as the judge himself.
So in this case, it is clear that accused had time to cool off. So when Cynthia confessed about her affair, the accused had 2-3 hours to cool off his sudden and grave provocation. But the mere intention to go to Ahuja's house was to talk about the future of her wife and him, because he wanted to make sure that Ahuja will take care of his children. So he went to Ahuja only to discuss and only to settle the dispute between them. But when he went there, the Ahuja provoked and they said some derogatory remarks about the wife of her accused, so which led to sudden and grave provocation. So in this case, it falls under the exception of section 300 of IPC.
In case of Yatendra Singh, Ajit Singh Chauhan versus State of Maharashtra, it is essential to note that the graveness and suddenness of provocation must be both simultaneous. The implies that firstly, the provocation must be not only the grave but also sudden, and that must be invited and unforeseen. Secondly, the act of the accused must be deprived from the provocation of such nature.
The witness, Anjani, Prem Ahuja's servant, was a nature witness who was present there and opened the door for Nanavati. She said that 4 shoots were fired in rapid succession and their entire event took place in less than minutes. It shows that no suffering took place.
Sir, in the present case, as we already discussed, that Pramod Akshin entered into a struggle due to derogatory remark made by Prem Ahuja, and during the struggle between the two shots accidentally went off. So it is clear that this couple is the thing which led to the shot of the bullet. So that's why it should fall under the category of accident and not in the case of murder.
After information she Parivarti that he wanted his revolver along with 6 rounds, he went off. He gave the reason that he was to drive alone to Ahmednagar by night and didn't disclose He put both the revolver and 6 cartridges in a brown river.
The reason behind his non-disclosure about the withdrawal of guns was that he wanted to kill himself. He could not disclose such thing about his naval authority. That's why he did not disclose the main reason why he wanted to withdraw the gun.
In Sahaj Ram versus State of Haryana, the accused, who is constable, fired several shots with a 303 rifle at another constable. One shot his victim benefit the knee of his right leg and he fall down. Even after that, the accused fired another shot at him, so the shot did not hit him.
In Budaram and others versus state of Rajasthan, in the aspect of mental state, is the lack of preparation on their part. The provocation must come unexpectedly. Hence, the provision that the provocation must be sought by the accused and must not be expected in any manner. This was reformed by Supreme Court.
This is clearly a case of murder mentioned in section 300 of IPC. Neither it is under section 80 of the IPC or under exception mentioned in section 300. Section 80, accidental in doing a lawful act, nothing in an offence which is done by act or misfortune and without any criminal intention or knowledge in doing of lawful act. In a lawful manner, by lawful means, which is proper care and cause. Illustration: A is a worker with a hatchet, and the head file of the kill a man who is standard by there was no want to proper cause of part of A. His act of the exclusive and not an offence. The murder cannot be said an accident as there was proper planning for accused.
Culpable homicide is not murder if the offender violates deprived of the power of self-control by will and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistakenly or accidentally.